Good afternoon. My name is Sudev, and I'm the CEO of EPLI Asia's Number Hub. Welcome to our third webinar in our Art and Science series. And this time around, we will be discussing on managing the types of employment relationships and its application in the gig economy. Employment Practices Liability Insurance, or EPLI, is a HR risk management solution that we have designed here in EPLI Asia's Number Hut. It is a standalone employment insurance for Malaysian employers that protects you against wrongful dismissal claims that arises from employment disputes. What we do is we provide human resources and industrial relations advisory services to companies here in Malaysia when you buy our EPLI policy. So for a sustainable HR risk management plan and solution for your company, which comes with advisors from competent HR and IR advisors, make sure you buy EPLI's 3-in-1 policy from EPLI Asia's Number Hub. This is the only one of its kind here in Malaysia, whereby EPLI Asia offers a 3-in-1 solution whereby we educate, advise, and protect businesses in employment-related disputes. For details on how your company can purchase this EPLI product by EPLI Asia's Number Hub, do email us your contact details to epli@epliasia.com, and we will contact you as soon as possible. The Arts and Science series is one of our way of educating every Malaysian on laws that govern our employment practices here in Malaysia and how it's actually applied in real life scenarios. The science being the law and the art on how it's actually applied. For today, our experts, Daman and also Supra, will be discussing on managing the types of employment relationships and its applications in the gig economy. I'm sure most of you have heard of various types of employment relationships. Yes, I'm referring to that hiring of full-time employees, part-time employees, fixed-term contracts, employees with freelance independent consultants, contract of services. And you've heard all of this throughout your career, and now we have this era of the gig economy. How does all of this apply? So the question is there a difference? Does the type of employment relationship that exists between an employer and the person that he or she hires a matter of importance? Is the wording in the employment letter important? Is there a difference between an agreement and a contract? And does the Employment Act cover workers in the gig economy? I am really excited to hear from our experts. So let's kick off this presentation and discussion by me introducing our moderator for today, Mr. Supramanya, who will then introduce Mr. Daman. So over to you, Supra. All right, let's start. Let's get this going.
Thank you, Dave, for sharing the information. Good to know that EPLI is moving well and ready to make history, bring in age-old product and modernize it. A much-needed solution for businesses, especially for Malaysian SMEs. A very good afternoon, everyone. Welcome again to our February Art and Science series. It's good to know that we have more than 300 participants sign up for this session. We sincerely hope you will greatly benefit from this session. Our topic for today, the art and science in managing the types of employment relationship and its application in a gig economy. In our discussion, we'll focus on 4 key areas. Firstly, having an understanding of contracts and the difference between a contract of service and a contract for service, and how we use these tools for our business, and not only in the new norm, but in the gig economy. The fundamentals of contract of service, what's the definition and how do we apply them? The fundamentals of contract for service, the definition and its application. And most importantly, understanding the gig economy and gig workers on how we're going to manage this workforce now and in the future. Along the way, we'll cite some court cases as well as reference points during the discussion. Our panel for today, we have the one and only Mr. Daman Sivalingam, EPLI's panel solicitor, who's also the managing partner of Daman Sivalingam and Partners, with over 25 years of experience in managing industrial relations and labor matters in industrial court, labor court, high court, and also court of appeal. Welcome, Mr. Daman.
Hey, Subra. Thank you for that introduction. Really pleased to be here. I think this is a such an important topic, and often we we may think that there is only one type of relationship, and that is your typical employer-employee relationship. And I think you've come up with some really nice questions that I hope will open the eyes of our listeners today, so they can go back thinking, "Wow, there's a few ways that I can do this." So I look forward to our session today.
Welcome, Daman. Thank you for being here. Since I've got a lot of questions for you, I think we should start immediately. But before we get into the details of contract of service and for service, just like to understand broadly, okay, what's the definition of a contract and also an agreement in the simplest of contexts?
Great question. Very often we are scared maybe when we hear the word contract, because there is this legality behind it. Hey, you breach your contract. But if you were to break it down, a contract and an agreement, very similar in nature, and a simplest definition I can give you is it's really a promise, an exchange of promises which are enforceable legally, where there are at least two parties. One party promises to do something in exchange for receiving something from the other party. Right? So, in a simple form, it is an exchange of promises between two parties where one party gets one thing in exchange for another thing by the other party. I hope that's sort of straightforward enough. We don't have to be looking at words, contract, and agreements from it's very legalistic. You must have stamping, you must have witness, must have commissioner for oaths, right? So I think it's a great starting point. It really is an enforceable promise in law between two parties.
Thanks, Dam. I also understand that contracts are agreements, but agreement may or may not be a contract. What's your view on that?
Okay. Nice way of phrasing it. See, I think what I'd like to start with is that the underlying premise of a contract is ultimately an agreement. One party has agreed to do something in return for something that the other party is supposed to do or supposed to pay. Right? So without there being an agreement, you cannot have a contract. Right? But the flip side may not be true. Meaning to say, just because you have an agreement doesn't mean it amounts to a contract. And the reason why I will say that is, if you look at, I'll give you a simple example. I had a discussion this morning with my son. So he's a little bit behind on his homework. I told him, okay, listen, if you finish your homework today, I will take you for dinner he wants to go to Burger King. That's an agreement. Now, let us say he finishes his homework, but I don't take him to Burger King as I'm expecting not to, right? And instead, I make him a Maggie mee at home. Now, if he wants to sue me, he has a problem. You know why? Because yes, we had an agreement, offer, acceptance, everything there. He even did his part, but last part I didn't do. But when he goes to court, he has a problem because he doesn't have the legal capacity, being a minor, to enter into the contract. So the agreement is there, but the formalities to transcend into a contract, which there are a few things which I will share in a while, some of those may not be there. So again, to sort of summarize, the underlying aspect of a contract is there must be an agreement. But to become a full-fledged contract, there are certain other legalities. So an agreement on its own may not be a contract without those formalities. But a contract will have an agreement within it, plus the formalities which allow it to be enforceable.
Cool. Thanks. So what's the definition of a contract in accordance to the Contract Act 1950? We have got a Contracts Act 1950 in Malaysia, right?
Yeah. I think first things first, it's sad sometimes when we sit down, we talk about the Contracts Act 1950, before I was born, before you were born, Industrial Relations Act 1967, Employment Act 1955. Maybe it's indication of the time is right for us to sort of amend our laws and modernize it. But the law remains the law, and the definition of a contract, according to the Contracts Act 1950, is basically a voluntary, deliberate, and legally binding agreement between two or more parties. You could have more than two parties in a contract. And here's the part, even the Contracts Act talks about this legally binding agreement can either be in writing or spoken or even implied. The action could even form a contract which is legally binding under the Contracts Act 1950. So it's a voluntary, legally binding agreement between two or more parties, and it can be writing, verbal, or implied.
Thank you. Referring back to your question, to question one and your answer, right? In order for the agreement or contract to be legitimate, right? What are the key elements that the contract requires to have?
Okay. Very generally, you have what people say offer acceptance. So where you have an offer acceptance, you have consideration, that becomes a contract. But I would go into a little bit more detail. I would say for it to be a legally enforceable arrangement, I would look out for 6 things. It's basically there needs to be an offer, there needs to be an acceptance, there needs to be consideration, there needs to be an intention between the parties to create a legal relations. So sometimes between two friends we have a talk, we have to say, hey, listen, if you do that, I will give you so much. Did we intend to make this into a formal legal relation that if you don't do this, I'm going to sue you? So the intention to create a legal relation is necessary. Capacity, I talked to you about capacity just now. A minor has an issue with that, or someone who may be mentally incapacitated may not be able to have the necessary level of capacity to enter into a contract which is enforceable. And of course, the part about consent. You can't, if someone is forced into entering a contract, that contract is not legally enforceable. So the 6 things again: offer, acceptance, consideration, intention to create legal relations, capacity to contract, and the parties entered into it with free consent.
Okay, interesting. So does the employment contract, or is the employment contract governed under the Contracts Act 1950?
Okay, so here's how it is, right? The Contracts Act is a specific piece of legislation that governs all types of contracts, right? And you have contracts for various things, right? Sale and purchase of goods, services, property. Employment is yet another subcategory. So yes, the employment relationship is also premised on a contractual one, and you do have general principles within the Contract Act which would apply, but overlaying the Contracts Act, when you talk about employment, you need to be mindful of specific employment-centric laws that will overlay the requirements in the Contracts Act. And a simple example would be the Employment Act. For an employee who comes within the scope of the Employment Act, you can't have a contract where you provide the person with less than X number of public holidays, with less than X number of annual leave. So that adds additional layers of requirements which you don't find in the Contracts Act. Further, you have, like the EPF Act, the SOXO Act, which states that you need to contribute to EPF, SOXO, HRDF Act, you have the Income Tax Act. So Contracts Act, generally for all contracts, overlaying that, you'll have to look into employment-centric legislation, which may provide additional requirements.
Thank you. It's interesting. You know why? Because the topic that we're covering, okay, is just not employment contract or contract of service. We're also covering contract for service. So that's the reason I wanted to know from a Contracts Act 1950. Right. So you made reference to Employment Act 1955. Okay. From my understanding, a contract can be entered either verbal or in a written format. Okay. But if it is more than 30 days, you must issue a written contract. Could you elaborate further on that?
Okay, so that's the provision that's in the Employment Act, which again is consistent with the Contracts Act, which allow contracts to be also in spoken format, right, or verbal. The Employment Act, however, adds an additional layer. It states that a verbal contract can only apply in cases where the contract is for no longer than 30 days. So they allow a little bit of leeway there. If it's 30 days or less, okay, fine, you don't have to go through the formalities of drafting a contract and getting it signed off. But it goes on to state that if it's more than that, it's mandatory. It's mandatory that it must be in written format. Now, of course, you need to remember that the Employment Act applies only for certain category of employees. Yeah, the 2000 and below, which brings an interesting question. One might suggest, so are you telling me if I'm outside the scope of the Employment Act, I can have a verbal contract for 25 years? So that's where there's sort of a little bit of a lacuna there. But just picking up on the provision that you talked about, you're right, the Act states up to 30 days can be verbal, anything more is got to be written. And I guess the logic behind why it should be written is in the event of a dispute, this becomes the focus of the court or the forum which is deciding on the dispute. You see, if it's verbal, Supra, let's say I had a contract with you, you hired me, you said, this is what I want you to do, and I will pay you 5,000 ringgit or whatever. And everything is fine, no problems. But now, let's say 3, 4, 5 months down the line, either I'm not doing my part or you're not doing your part, and there is a dispute, and and the dispute cannot be resolved by negotiations. We end up in court, and if it is not in written format, the terms and conditions of the employment relationship become difficult to prove, because it then comes back to what was verbally agreed. And I may have one particular version which is different from your version, and then it's up to the court to decide, hang on a minute, so what really are the terms? And so discretion has to be exercised. But when it's in written format, all the discretion is gone. All you have to do is, Young Arif, here's the contract, here are the signatures of both the parties. This right here encapsulates the terms and conditions that both of us agree. So the proving of the terms do not pose a challenge where the employment contract is in written form.
Thank you. Okay, I understand there are two types of contract, right? We have gone through this with regards to contract for service and a contract of service. I first encountered this in the mid-90s, hiring specialists from abroad in the oil and gas industry. Really, what's the difference between these two contracts besides the usage of the word of and for? I trust there's a big difference between both the words. Could you give us a detailed explanation from a legal perspective?
Sure. And my presentation later after this session will go into a fair bit of detail on this. But right there, this question, I think, is really what today's topic is about. It's the difference between an of and a for which seems negligible, seems almost no difference, but the impact or the consequence from a legal perspective is absolutely huge. Generally, a contract of service gives rise to an employer employee relationship. And if you have an employer employee relationship, and let me cut to the chase, the problem we have is termination. The headaches that employers have, how do I get rid of an employee? And if I don't do this right, because it's an employer employee relationship, let me be prepared to get whacked in court, and let me also not forget to take my checkbook and go to court, right? Whereas the contract for service does not create an employer employee relationship, but a principal and a contractor relationship. So think about it like a contractor that you enter into a contract with to renovate your house. That person is actually doing work for you at an agreed rate which you have agreed, but that relationship does not transcend into an employer employee relationship. It remains a principal contractor, and the reasons behind that I will go into detail, but that is the essential difference. And the advantage that most people want to take from this is that issue on termination. Principal contractor relationship, can wash my hands like that. But as you and I know, employer employee relationship, different ball game altogether.
Good, thank you. But what I'm trying to understand here is how does the change of word, the of really imply employment and the for implies non-employment?
You are really that's a really tough question, and I wish I'd done a bit more research on what was the intention, because it doesn't become apparent when just by looking at the words that this means this, and the whole consequence, you're literally going left and right in a junction, it's opposite direction. And the what I can tell you, answer your question, is that the usage of the word of brings about certain guidelines. The courts will impose on a contract of service certain additional obligations. I guess the short answer to your question would be the difference between the word of and for creates an entirely different relationship between the contracting parties. And if you were to challenge me on the reasoning, what's the difference? I don't, I did a bit of research, and there's nothing really solid that I came up with. It is the accepted norm that a contract of is indicative of employer employee, where all the obligations of an employer comes to bear. Whereas the contract for service, it's I guess, the part of it is, who am I doing this for? I think that's where the beginning of the term came, but it's not. I don't think it's self-explanatory, So it's later when you go into some of your questions as well, right? If you look at the independent contractor, the work that he is doing is actually for himself, because let's say you enter into a contract with ABC Sdn Bhd for ABC Sdn Bhd to do renovations to your house. So the person who's doing the work is doing it for ABC, or which is owned by him, or for his own uh, sole proprietorship. And I think that's where that word for meant, okay, it's not to the benefit of the employer.
Thank you, sir. From your experience, okay, I'm sure you have seen a lot of employment contracts reviewed or even drafted, right? What would you say are the common errors that you have encountered while reviewing the contracts of employment?
Okay, I would say that the biggest single error is that there is a lack of understanding of the relationship. You need to understand that if the nature of the relationship is one which is an employer employee relationship, no amount of wording, no amount of masking is going to fit that into a contract for service box. It will be a square peg in a round hole. It's not going to fit. So I think the biggest problem that we have is there is the lack of understanding, but the employer there mati still wants it to be a contract for service, and so all the terms that are put into that contract tries to simulate a principal contractor relationship, but that actually doesn't work in their day-to-day relationship with the employee. So very common example could be a contractor is paid EPF. If you put that in the contract, that's an indication right there you're an employer. Okay, so it could be simple things like that. It could be making reference to the word salary, wages, right? So when you put in words like that, you start to confuse or blur the two. But my starting point, or rather my personal view, is that the biggest mistake is people do not understand that these are distinct and separate relationships that cannot be converted just by changing the labels.
Thank you. Now let's discuss on the contract of service. I think a lot of people have been waiting, right, to understand the contract of service. My first question under the contract of service, right? What's the difference between a letter of offer and a letter of appointment? Some companies tend to use both. Some use either one of them, right? So could you give us more details with regards to letter of offer and letter of appointment?
Okay, so my initial view on that is these terms, letters of offer or letters of appointment, are not legal terms which are defined in any act. So it is become more of a HR practice. But I can see the value in having the slight differentiation there. You see, when you make an offer, the person that you make an offer to, normally the employee, has the discretion of accepting or rejecting. So it may be a bit premature. Well, it is premature to say that you are an employee the moment I issue a offer letter, because the offer has not been accepted. There is no contract even. There's no agreement even. Even an agreement requires an offer and acceptance, right? So I think the practical HR development in this field suggests that, okay, first thing what I should do is I make that offer, and that typically is called the letter of offer, for which the employee then signifies either is he accepting this or is he rejecting this. And if he rejects it, it ends there. No contract is formed. But if he accepts it, that's when there is a formal relationship that is being formed. And that formal relationship normally is what you call it. It is formalized by way of the issuance of a letter of appointment. Some people call it a contract of employment, right? So there are various terms that may be used. But my view, the differentiation that the general HR practice has taken over the years is that the letter of offer is at the point where the employee or potential, I'd use the word potential employee, has not agreed yet. And so hence it's merely an offer. Whereas the appointment is a crystallization of that relationship. But it's an interesting point here, you see. Let's just talk a little bit, slight digression. When we talk about the handbook, when we talk about code of conduct and so on. So when I make an offer, do I have to tell you the terms of the handbook, the terms of the code of conduct? Now, one would argue you must, because
Yep, correct.
it's not fair for me to accept this not knowing that there's some quirky, weird term in there, which I will not accept something in the handbook, right? So a lot of times the practice is that at the time the letter of offer is given, the person, the potential employee, has no visibility of the handbook, so the trap has been set. Come now. Then when the fellow falls in, signs that, we whack him in the letter of appointment where the clause says, please note that in addition to this letter of appointment, the terms and conditions found in the handbook, policies, blah, 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 are part of the terms and conditions of employment. So you got to bear that in mind when you are trying to formalize this relationship. My suggestion would be, even when you make the letter of offer, it may not be practical to give the handbook, especially where someone may say, well, I'm not joining you, and then the guy gets your handbook and whatever. But I think today you've probably placed these documents on your intranet. So it would be good to point them into that direction and tell them, listen, you make your decision after having studied this, because those are also part of your terms and conditions.
Thank you. That's really good advice. So under the contract of service, which is meant for employment, right? We have multiple types of employment contracts. Right? We've got the full-time permanent employment. We got the full-time fixed-term employment. We also got part-time employment. Right? Is there any other types of employment? Maybe I would have missed out. So maybe you could share with us and for the audience as well, right? What are the differences between these three different types of employment contracts, which falls under the contract of service?
Okay. So right there itself, Supra, I think it's an important point for employers to understand that even within the bucket of contract of service, which is really a employer-employee relationship, you are not confined to to choose only one type. You do have options. So the first one that Supra referred to is full-time permanent employment. Now, what does that indicate? The fact that it's full-time suggests the employee is putting in a whole day's work every day that the employee goes to work. And when you talk about permanent employment, it is referring to the fact that if everything remains equal between now and the retirement age of that employee, the employee is a permanent employee who is allowed to work up until the retirement date. So that's what permanent means, and full time means you're working the full hours in a day. The second one you talked about is full time fixed term employment. Now, what does that mean? So the full time remains the same, i.e., they are working the full hours in a day. And what are the full hours in a day? If you look at the Employment Act, the normal hours of work are something that employer is free to dictate. Of course, you got limits within the Employment Act. You can't go more than X number of hours and all of that. But the second part is where the difference here is between a full-time permanent and a full-time fixed term. So the permanent I talked about, if everything remains equal, meaning no misconduct, no performance issue, no retrenchments, the employee works until the retirement. But a full-time fixed term employment means that contract is only for a defined period of time, which then means the person is working full time each day, but they do not have a right to work until the retirement, but only until the expiry of that fixed term contract. So there is a predefined period. The third part, that the third type of employer-employee relationship that you alluded to is the part-time employment. So this is a situation where someone is not doing the full 8 hours or 9 hours in a day, but a fraction of that. And here there's a good point that you can make. You can even have a part-time employment for a fixed period. Likewise, you can have a part-time employment for a permanent period. It might be the case that your business is such that you only operate 4 hours in a day, and that's how you expect to operate for the rest of time. So in your situation, you don't need someone working 8 hours. You could actually hire everyone on a part-time basis, and they could work up until retirement if you so choose. But you could also say, well, I'm going to try this out. I'm going to have 4 hours a day for a year and let me assess. So in that sense, you only want someone to work 4 hours a day, which is part-time, not the full-time. But you also are imposing a defined period of time, which is it's only for 1 year. So the difference between the part-time as opposed to the other two is that the number of hours that are clocked in a day are less compared to a full-time employee.
Thanks. Okay, now let's dig deeper into the part-timers. So we have got a regulation, Part-Time Employees Regulation 2010, which clearly states that this applies for those who work between 30 to 70%, okay, of the standard working hours per week, right, of the company, or a maximum of 48 hours, right? will be classified as part-time employees. Okay. So my question is, does it mean for those who are working below the 30%, which the part-time regulation doesn't actually cover, okay, will be considered as casual workers? So would that mean that they are not entitled to any employment benefits whatsoever, and they are treated like a contract for service? Okay. I'll give you another. I'll give you a scenario to to clarify this. Say I hire them, okay, on a 2 hours per day basis, 5 days a week. Okay. So they only come. So technically, they're only working about 10 hours a week. Okay. So if my total work hours is 48 hours, they're actually working lesser than 30%. So would they be construed as an employee or under the part-time guideline, or would they be construed as a freelance independent contractor under a contract for service?
By definition of the regulations, they would then be classified as not employees. So therefore, it is their relationship is predominantly governed by what's in the contract. So any benefits that they are entitled to is as per what's stipulated in their contract. So is it a fair basis of doing it or not? Because the definition is 30 to 70%, less than 30%, it doesn't amount to a part time, so it is viewed as a casual worker. Casual worker typically is you work as and when there is work to be done, and that creates that independent contractor relationship.
Okay.
Yeah.
And so in this case, he can, but it's still up to the company to basically decide if I want to put him, because if he works 5 days a week, he's got no annual leave entitlement, no sick leave entitlement, right? Okay.
Correct. In fact,
And
incidentally, right? If I can just add
mhm,
there, Supra, even for the those who fall within the 30 to 70%,
mhm,
if you notice in the regulations, they don't talk of maternity leave. So they,
mhm,
they scale down everything else. They go on an assumption of, if you're a part-time employee, you will get 70% of the entitlement found in the Employment Act. So if annual leave is
correct.
X amount, you get 70%. If it's medical leave X amount, you get 70%. But maternity leave is not mentioned. So a part-time employee not entitled to maternity leave.
Okay, I'm learning a lot right now. Okay, the I'm referring back to your statement earlier with regards to part-timers, okay, on fixed term basis, right? So if I hire a part-timer on a fixed term basis, say on year one, then I renew year two, then I renew year three, then I renew year four, could this contract then be deemed to be a permanent contract?
My opinion, it can. My opinion is that the principles of Hanchiang High School, which I will refer to during my presentation later, would apply equally to part timers as well as full timers. Because to me, the question of whether this is a genuine fixed term contract or not is not dependent on whether the person is a part time or full time employee, but rather dependent on the nature of that relationship. How long would you need this person? If the fact that it's being renewed again and again and again suggests that this is actually more of a permanent relationship, but the company there is using a fixed term to limit their liability. So my opinion is that even a part-time employee, if you put them on a fixed term employment contract, but you keep renewing it, you run the same risk as you would with a full time employee, i.e., that fixed term contract may be struck down by the court as it being not genuine.
Okay, under the law or under the regulation for part-timers, there are specific employment benefits like leave, public holidays, medical leave, and etc. for part-timers. In the absence of such clause being specified in their contract, okay, the employee then automatically assume they will be entitled to the full-timer benefits, or would you have to refer back to the part-time regulations?
Okay. Okay, so if I hear you correctly, Suprasu, you're talking of an employer who has two types of employees. You have got part-time employees as well as full-time employees, and of course, for full-time employees, all the benefits are stipulated. But then for the part-time employees, they are not. So
Yeah.
in that situation, what benefits would apply to them? Now, my view is that first things first, that the part-time regulations only apply the same conditions of the Employment Act, the four categories, 2000 and below and blah, blah, blah. So if they come within that category, even if you don't have any benefits stipulated, the the regulations would apply, right? So the minimum of in the regulations would apply. But let us say you've not stipulated anything. Can someone come and argue, well, since you don't stipulate this, it would make logical sense that the benefits which you extend to full timers would apply to me? My view would be no. My view would be if they come within the scope of the Employment Act and there is an absence of written benefits, the part time regulations benefits would apply to them and not the full time employee benefits.
Next question. What are the rights of employees? Say, if I terminate them, can they still file under section 20 for unfair dismissal as well?
Yeah. So
Which
if you look at the see section 20 is from a different act. It's the Industrial Relations Act, and the Industrial Relations Act does not distinguish between fixed term, permanent, part time. Even they use the word workman. So if someone is comes within the definition of workman, they would have access to the provision of Section 20 as well. Now, I remember having a discussion with a fellow lawyer who was saying, I disagree with that because his view was, listen, the whole idea or notion of the Industrial Relations Act or Section 20 is that security of tenure. You don't lose your job without just cause or excuse. So he argues that if security of tenure was the principle behind the need for Section 20, then by definition, a part time employee has less security of tenure, and so Section 20 should not apply to. I disagree with that. I feel that whether you're part time or full time, your security of tenure is really dependent on whether you have a period fixed in your contract or not. And if you have a period fixed in your contract, assuming no extensions, blah, 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 then that person would not have security of tenure. But if you do not have a defined period, the fact that you are a part time employee should not dilute your right to security of tenure.
Thank you.
Yeah, so they too.
My next question. Yeah. Yeah. Please go ahead. Okay. My next question is, okay, in the event they file under section 20 and goes to court, right? What would the limit of liability be? Say, because right now the most court award goes up to 24 months for back wages plus 1 year for every year of service, right? And for probationers, you've got a maximum of 12 months, right? For the back wages. So would a part-time employee, right, then fall under the 12 months or the 24 months in terms of back wages award if I lose?
Correct. Okay. So in my opinion, they would have the same rights as a permanent employee. You see, when you talk of a probationer, let's look back at the 12 months limit that was introduced, right, in the regulations of the Industrial Relations Act. And I think rightly so, because again, going back to what I said just now, the concept or principle behind Section 20 is security of tenure. A probationer, by definition, is someone who needs to prove himself to be worthy of being confirmed. Meaning to say, both parties, employee and employer, understands that until and unless you are confirmed, you do not enjoy security of tenure. So in those instances, the court said, because they don't enjoy security of tenure, let us limit this to a maximum of 12 months. But for a part-time employee, the security issue doesn't come into question. I mean, listen, there might be some relevant facts that we need to take into account. For example, in that particular company, every part-time employee only works for a year. Then, even though the part-time contract does not stipulate an end date, it might be something that you can convince the court. But my short answer to your question would be the 12 months cannot apply to them because that's made specific to probationers.
Okay, noted. Now let's go to fixed term contracts. Okay, if I recall, right, you handled a case recently on a continuous extension of fixed term contract. Could you be kind enough to share with us a brief background of the case and how did it go? Because sometimes, from the court case reviews that I'm doing, the industrial court tends to, okay, this particular case is deemed to be a permanent, and in this particular scenario, you know what, it's a fixed term contract, right? So could you share with us your recent case that you just won in court?
Okay. Before I go into the facts of that case, the starting premise on a fixed term contract should be that the job for which you have used the tool of a fixed term contract should be a job which is needed for a fixed period or a temporary period as opposed to a permanent period. So if the job itself is required indefinitely, using a fixed term contract, already you're using the wrong tool. And I think that's the basis of the Han Chiang decision, that they were all teachers. You can't run a school without teachers. So the role of a teacher in a school is a permanent role. And that's one of the main reasons the court struck that down. Of course, the other issue there was to further fortify this principle, they kept renewing the contracts, which clearly show that it is a job which in those circumstances is permanent in nature. Yeah. So having said that, I'll share with you the case that I did. So in the case that I did, there were as well, I think there was a total of 6 renewals, if I'm not mistaken. But the we managed to explain or demonstrate to the court in this case, it was very much project based. It was very much project based. And this is one challenge of fixed term contracts, because when we define a contract by time, especially on a project which the parameters of the project can wildly run, thereby extending the project or shortening the project, you run into this risk. If it, especially in large projects, the one that I did was oil and gas, and that's a huge project where they had to build loads of stuff, exploration and all of that, and the timeline kept slipping. And because the timelines kept slipping, the need for the person continued. So there were extensions. But the good thing in that case was the extensions were, in many of the instances, were very short time, like extension of 3.5 months, a further extension of 2.5 months. I managed to convince the court that the only reason these extensions were being made is purely because the project for which this person is hired has now been extended beyond the control of the employer. And we could show that upon eventual completion of this project, this role will no longer be there. So we were able to demonstrate to the court that this role is not actually a permanent role. It is tied to a project, but the challenge we had in this case was the project got repeatedly pushed, and hence the contract got repeatedly renewed. I also managed to demonstrate to the court, and the employee agreed to this. Every time there was an extension, the employee knew very clearly in her mind that upon this extension, there may not be a further period of employment. And how did we manage to prove that? Was the employer was asking, is there any chance that I could be converted into permanent? Or is there any chance that I could see in that situation? The company was also working with third-party contractors, and upon completion of the project, part of that project would move into the third-party contractor. So there was an email where the company said, listen, there might be the possibility that upon the expiry of this contract, you might be able to get a job with the third party because those guys will be running the project. So that also showed to the court that this job in this employer was definitely tied to the expiry or conclusion of the project, and it wasn't a permanent job in nature. So we managed to put all of that and show to the court that despite these extensions, the job was never intended to be a permanent one, and more importantly, the employee was very aware of that fact.
Thanks. Congratulations on that
Thank you.
court award. Okay, I'd like to give you a scenario here. If I have a fixed term contract employee, and say I fix it for 24 months, okay, then I decided that his performance is not good. But I've got two scenarios. But okay, I decided his performance is not good. Okay, therefore I decided to, end the contract by serving him the notice. After 1.5 years, there's still a 6 months balance in the contract. Yeah. Can he file a case for wrongful dismissal under Section 20?
Okay. The question of can he file a case? Answer is yes. I think the bigger issue would be, would he succeed? Can a company terminate a fixed term employee prior to the expiry date of the contract? And my answer to that is clearly yes. You see, everybody understands that a permanent employee has got greater rights compared to a fixed term employee, right? So, because they can work until retirement and so on. So, if that is the case, and if it is the case that a permanent employee can be terminated on grounds of poor performance, surely it must follow that a fixed term employee can also be terminated for performance. It can't be the case that just because you're a fixed term employee, okay, I cannot touch you for 2 years. What happens if the company closes down after 6 months? 6 months into the contract, it's impossible for that contract to be performed. So even a fixed term contract can be terminated prematurely, provided, and you will be able to succeed as an employer in court if you can set up that the dismissal was with just cause or excuse. So in the example that you cited, if the person was released on grounds of performance, we must be able to prove that we went through that PIP and gave him opportunity to improve, and yet he didn't improve. And so the court could, if the court agrees with that, the dismissal can be upheld, and there is no further compensation that the court would order.
Say, for instance, I'm a bad employer, right? The performance PIP and all that stuff I didn't do. It's just that I decided, didn't have time to do all this, right? Because I got to focus on the business and bring in revenue, given the COVID situation. So what would be my damages in court? Would I be exposed to 24 months, or would I be exposed to only the balance of the 6 months?
Only the balance, and that's one advantage. Like your risk is capped. It's only the balance.
Yeah.
Again, here I'm giving you the answers based on the assumption that it is a genuine fixed term. It's not renewed. Because if it's renewed many times, and the court says not genuine, then the full 24 months all applies.
Okay. Cool. Okay, my next question to you on this, I know we're running a little bit out of time. Go through quickly. Okay. How does the court actually determine the legitimacy of a fixed term contract? I'm sure they've got some kind of a litmus test, right, to determine whether this is a genuine fixed term contract or this is a permanent contract disguised under the fixed term.
Okay. I wish I could give you a scientific formula which you can then use and say this one definitely fixed term, this one is not a genuine fixed term. But I will give you the principles behind it. The biggest one that comes to my mind would be, um, what is the nature of is that job permanent in the circumstances of that particular employer? And if it is permanent, what is the reason that we put the employee on a fixed term contract? So, if the job is permanent in nature, and we now, but let me pause to say something here. Just because the job is permanent in nature doesn't mean that you cannot hire someone on a fixed term for that job, right? What it would mean is if you hire someone on a fixed term, but you keep renewing again and again and again, then you run a major risk of the court saying this is a permanent contract. But let's say, following Han Chiang's example, right? So I'm a school. Definitely, I need teachers as long as my school is open. But it is my principle, for whatever reason, that I will only hire teachers for 2 years, and after that, I will refresh. In fact, a lot of the GLCs do this for senior level people. They are hired
Yeah.
on a fixed term contract, and they are occupying roles which are permanent in nature. A CFO role, a COO role. They are permanent, but in the GLCs, they want fresh ideas, new people coming in. So that's why they want the churn. So if you have someone on a job which is permanent but only on one fixed term, you don't have a problem. The problem creeps in when the job is permanent, you brought someone on a fixed term, and you keep renewing the person on a fixed term, because the industrial court, being a court of equity and good conscience, would view that as the employer using the tool of a fixed term to circumvent Section 20. So that's to me, would be the best test. Think about it. Is this a permanent job? And if it is a permanent job, do I consciously, like the GLCs have done, do I consciously only want someone for X number of years and thereafter I want to refresh? Or is it the case that actually this person, as so long as he's good, I can keep him in the job? That's when you want to think about, I don't think a fixed term is the right tool for me here.
Thank you. Just one last question before you go to your presentation, right? For a fixed term contract, could I put probationary period in it, right? Especially if I'm hiring somebody on a short fixed term period, say 3 months, 6 months. So I understand if 1 year or 2 years period, I can have a probationary period. But if I'm just hiring for 3 months or 6 months, does it make sense to put a probationary period? Because my limit of liability is within that 3 months period anyway.
Correct.
What's your advice?
For me, from a logical perspective, it doesn't make a lot of sense. And the reason behind that is your risk exposure. If you're talking about 3 months or 6 months, that's your maximum risk. And if it's for such a short-term period, I would think the danger of getting the wrong person for the job can be better mitigated by a more robust interview process as opposed to having a probationary period. Is it wrong to have a probationary period in a short fixed term contract? No. Is it illegal? No. But does it make sense? Imagine you go to someone, let's say I make this offer. Okay, Supra, I'm offering you for 3 months, but first month probation. If you don't make it, it's like the guy is like, what's wrong with you? So that's where I would sort of my view is on.
Yep. Thank you, Daman. I've heard you say this many times, that contracts were supposed to be a tool for organization to use to manage the workforce depending on the needs of the business, and not a tool to try to save money. I trust you will elaborate further in detail in your presentation. So now I would like to invite you to start your presentation, okay, on how employment contracts apply, contract of service and for service apply in a gig economy. Please proceed, Mr. Daman.
Thank you. Could I get my slides on, please? Okay, so the art and science of managing the types of employment relationship and its application in the gig economy. So let's go with this. Let's start, please. Can I move to the next slide? So let's look at the employment relationships, and I think Supra did talk about the first three, which come under the category of contract of service, and the difference between of and for. I will be going into some detail hereafter. Generally, you've got these types of, I call it employment relationship. I use it loosely because if you look at the last two, independent or casual employment, is not really an employer-employee relationship, but the output is as if there is a, it still comes down to somebody doing something for another person. So that's why I've categorized these five. But the top three are typical employer-employee relationships, and the bottom two are typically principal contractor relationship, unless there's some wrongdoing there, which could be viewed as a court as a employment relationship. So you've got permanent employment, fixed term employment, part-time employment, independent contractors, and casual employment. So I will now take you through the differences between these types of relationships. And if I could move to the next slide, please. So the first one is, of course, the permanent employment, which is the most common form of employment. Most people are employed on full-time permanent contracts. And the key features on these types of relationship are that you have, the employer has a very high degree of control over the employee. So not only what is the employee supposed to do, i.e. the output can be measured, but also the how the employee is doing the work is sort of, there's a high level of control, which is why if an employee does something wrong, where you have a permanent employment situation, you can take that person through a disciplinary process, or if somebody is not performing to expectations, you go through the performance management. So there's a very high degree of control that an employer would exercise over an employee in these type of relationships. And the biggest negative, of course, is that it can be legally complicated to terminate these types of relationship. By law, a termination of this type of relationship would require the dismissal or the termination to be based on just cause or excuse if it's challenged. Let me move to the next contract, please. Fixed term employment. So what are we talking about? We're talking about contracts where an employee is hired, but as opposed to permanent or up until retirement age, the contract is actually fixed. And it's fixed by time, or interestingly enough, Section 10 of the Employment Act 1955 specifies that you can have a fixed term contract which is defined not just by time, but also it could be upon completion of tasks. And that is, to me, is a very useful tool that you can use, because as I mentioned earlier, sometimes when you have project-based roles, it may be very difficult to clearly define the end date. Think about large construction contracts. A company has been appointed to put up a 70-story building. Yes, the project timeline suggests it's going to be 3 years, and so you hire people for 3 years, but because of delays, it get extended into 3.5, 4 years, and so on. That's in that situation, you can consider the alternative in the Employment Act, which talks about you could actually have a fixed term contract where the end is defined upon completion of milestones or tasks. So in a construction scenario, you could say the duration of your contract is from 18th of February 2021 until obtaining certificate of fitness. So we don't put a date when the contract ends, but rather a milestone. So this takes away the challenge that one might face, where you don't have complete clarity or control over the end date. Other aspects of fixed term employment, similar to permanent employment, there is a high degree of control over the employee, discipline, performance management. All of this applies during the fixed term period. Unlike permanent employment, however, fixed term employment is less complicated to terminate the relationship, provided it is a genuine fixed term contract. And the law basically views termination at the end of the fixed term contract as expiry of the contract due to effluxion of time. And that is perfectly fair reason for termination, and it's accepted by law. Now, the challenges that you have for fixed term employment, one I've already referred to earlier, is the challenge posed by Hanchang High School, which is if you keep renewing an employee on a fixed term contract, there is a likelihood that the court would view this as a permanent employment which is disguised as a fixed term contract. So you could be caught out if you were to hire someone on fixed term and keep renewing. And as I mentioned earlier, you've got to be careful about whether the job is a permanent job. And if it's a permanent job, the more times you renew, the more likely you run into this challenge. I've also put in there another challenge is the Minimum Retirement Age Act 2012, which has a provision that stipulates for employees who have a basic salary of 20,000 ringgit or less, the fixed term contract, including extensions, should not go beyond 24 months. So 20,000 or less, you should have it maximum up to 24 months. And that's a provision that's found in the Minimum Retirement Age Act. There is another provision there which was brought in by amendment. If someone's basic salary is 20,000 or more, then you can have a fixed term contract for up to 60 months or 5 years, right? So 20,000 and less, capping suggests in the act is 2 years, above 20,000 basic, up to 5 years. Can I move to the next slide, please? Part-time employment, we spoke a fair bit about this just now, so let me quickly recap. So you have got the regulations which deems someone whose salary who comes within the scope of the Employment Act, i.e. wages are less than 2,000, manual labor and so on, if they are working between 30% to 70% of the hours of a full-time employee. So when you compare, if the full-time employee is doing, for simple maths, let's say they're doing 10 hours in a week, 30 to 70% would mean this employee is doing between 3 to 7 hours. Now, it's important to note that if you don't have normal full-time hours, the regulations state you go by the default, which is the 48 hours in a week. So what does this mean is if someone is working more than 70% of the time relative to the full-time employee, that person is viewed as a full-time employee. And if someone is working less than 30%, they can't be a part-time employee, and that they would be, by definition, be treated as a casual worker. So part-time employment, there are many similarities to full-time employees, i.e. you still have the high degree of control. It is still a contract of service. So the big thing would be the reduced hours. And if you look at the regulations provide for annual leave, medical leave. So the general benefits apply. But as mentioned earlier, maternity leave is not provided for part-time employees. As stated earlier, degree of control is retained, so you can discipline or performance manage a part-time employee. Supra asked the question just now about can a part-time employee pursue an unjust dismissal case? There is no reported case to my mind or to my knowledge. But as I told you earlier, it is my view that they have a right to do so just like a full-time employee. Of course, obviously, in their case, their salaries are much lower. So from a ringgit perspective, the quantum may not be as high as a full-time, fully paid employee. So that's insofar as part-time employment is concerned. I can go to the next slide, please. So now I'm moving into the non-employer-employee relationship, at least by definition. Okay, so like I said, the definition is one thing, but sometimes you have people who put on the label, this is an independent contractor. But when you go through the details of the contract and when you examine the way the parties are working with each other, it might actually be the case that this is not an independent contractor, but rather an employer-employee relationship. And so you've got to be mindful of that. So the design philosophy behind independent contractors is that this is not a tool for the employer-employee relationship. you have a low degree of control over the employee. Sorry, not the employee. Yeah? You have a low degree of control over the consultant or the contractor. So you don't use discipline, you don't use performance management. Those are not tools that you would use to manage an independent contractor. And the reason for that is it's actually quite straightforward to terminate the relationship, again, on the assumption that this is a genuine independent contractor and not employment relationship that's being disguised. So, because it is easy to terminate the relationship just by issuing a letter, if there's a notice period, you'll have to comply with that notice period, and you can very quickly terminate. And if it's a genuine independent contractor situation, you are insulated from any complaints under Section 20. Now, the question about how can we know whether this is a employment relationship which is disguised as a principal contractor relationship, I will be talking in detail about that after this. This is really about the contract of, contract for distinction. But what I'd like to share with you is there is no scientific formula where I can say, okay, applying this is definitely an independent contractor, and this is not an independent contractor relationship, but rather an employer-employee relationship. So more on that in the slides that will follow. And next slide, please, Shadi. The last one I put there is casual employment. This is really a situation where you talk about seasonal work. The person gets paid if and when they do work. So you talk about, someone who is coming to pluck fruits from your orchard, or your estate. So the guy, if he comes in, he's got a day rate. If he spends X number of days, X number of hours in a day plucking your fruits, and then he gives you whatever the output of the day, and he gets paid. It's up to him completely to decide whether he wants to come in the next day. And there's very little in terms of discipline that you can take action against the employee, against this person. Obviously, it's also very easy to terminate the relationship between someone who has a casual employment relationship with the principal. So low degree of control, similar to independent contractors, and in its true form, it is not an employer-employee relationship, which makes termination quite straightforward. Next slide, please. This is really the highlight of our session today, I would like to think. Contract of service versus contract for service. One different word, but huge change in how the law views these two different relationships. Let me get into that. Next slide, please. I put it down here in a snapshot. General differences. Contract of service, you're talking of an employer-employee relationship. Contract for service, it is a principal independent contractor relationship. Contract of service, you got to comply with statutory deductions. You don't have to for contract for service. For those on a contract of service, employer-employee, full degree of control, PIP, DIs, all of that can be done. Contract for service, there is hardly any or minimal degree of control that you would have over the contractor. For contract of service, you may be bound by the Employment Act for those who come within the scope, and you would be bound by the Industrial Relations Act in the event of termination. But for the contract for service, you're not bound by the acts. You are bound by what's stated in the terms and conditions between the principal and independent contractor agreement. For contract of service, typically you pay salary and allowances, whereas for contract for service, it would be fees. Typically, invoices would be issued by the independent contractor, and the principal pays for those fees upon receipt of the invoice. So it's not a salary or a wage, but rather a fee-paying situation. If I move on to the next slide. So the big ticket item is on the degree of control. Contract of service, we have got full degree of control. What do I mean by that? The employee has to comply or observe with the hours of work. The employee has to observe leave policies, so they can't just choose not to come to work. If they don't come to work, they need to have a valid explanation. It's got to be a medical reason, or they've got to apply for annual leave. So there's a high level of control that the employer would exercise over the employee. But when you talk about a principal and contractor relationship, you don't have to go through performance management, disciplinary process. You don't have to have cause or just cause or excuse to terminate. You don't end up in the labor or industrial relations department. But if there is a dispute, it would end up in the civil court. And of course, because it's not an employer-employee relationship, the issue of wage doesn't come in. So questions about minimum wage, retirement age, all of these things do not apply in a contract for service situation as opposed to a contract of service. So that's like a snapshot differences. But I'd like to take you into the next part now. Next slide, please, which is a more detailed study of how do you distinguish between a contract of and a contract for. And I need to start by um, telling all of you that I wish I had a one size fits all. I wish I had a tool which I can tell you, with this tool, you automatically plug in the facts and you will know for a fact with 100% legal certainty that this is an employer-employee relationship and this is a principal-contractor relationship. There isn't one. There is no one perfect test or formula that I can provide. I know a lot of you will have burning questions, but surely I can make this be a contract for service. Surely by using some words, I can make this be 100% contract for service. The answer is no, you can't. The law has got ways in distinguishing between the two. And here's the part that's tough. The distinction is not always obviously clear. And I stress again that there isn't one singular acid test which you can repeatedly apply to achieve consistent, clear answers. Almost every case will have different facts which could lead to different results. And if you study the body of law, you will find that there are many cases which have got similar facts, largely similar facts, but some slight difference in the facts could result in the court saying, no, this is a contract of service and not a contract for service. Whereas in another case where 90% of the facts are similar, but 10% differentiation, and a different court comes with a different answer. So that is why this is quite a challenging area to, if you are looking out for an easy and absolute clarity around what is a contract for service or contract of service. I don't have an answer that can give you that, and I suspect nobody has. Can I go to the next slide, please? Generally, the laws have used various tests over the years, and the first one goes back as far as 1880, what is known as the control test, which is why you notice earlier we were talking about degree of control. It came from this control test. In the case of Ewan and Noakes, the principal test that the court used was that does the master have a right to direct his servant? Now, master means employer, servant means employee. I know very derogatory terms, but back in 1880, these were socially acceptable terms. So, does the employer have a right to direct the employee as to what is to be done and how it is to be done? My view is the how is the real distinction. You see, when you have a principal contractor relationship, so let's say I bring in a contractor to come in to do renovation. We have got understanding of what I want. I want to have 2 additional rooms and 1 additional bathroom. That is the what. But the how you do it, there's a lot of flexibility there. Now, whether the contractor does it himself, whether the contractor wants to bring other people, whether the contractor wants to outsource this to another company. So all of that is left to the discretion of the contractor, and the principal does not have the right to exercise that level of control over the contractor. Yeah. So the what and the how is dictated by the employer, and that is essentially the control test. If you can dictate the what and the how, it shows that there is a high degree of control, which then shows it is more likely an employer-employee relationship. However, I'd like you to look at the case of Sunday Tribune, where the court recognized that given the difficulties in relation to skilled workers who are told what to do but not how to do it, the court said the contract test was no longer of universal application. And you cannot just use this control test as the definitive test, especially the court said in the modern context. So the court basically said the nature of the employment relationship is not so simplistic that you could just use the control test and conclude this is employer-employee or this is principal-contractor. So this is one test, but even that, if you look at Sunday Tribune, the court has already diluted the efficacy of the control test. If I can move to the next slide, please. The next, or another test that the law has used over the years is what is referred to as the integration or organization test. This is a judgment of Lord Denning, perhaps the sharpest legal mind that ever walked the face of earth. So in Stevenson, Jordan and Harrison Limited and McDonald Evans Limited, the court stated that an employee is a person who is integrated with others in the workplace or business, even though the employer does not necessarily exercise high level of control. So what does this mean? This is basically saying that even where there is a low degree of control, but that person is so integrated with everybody else in the workplace that if you took that person out, this could collapse. The courts view it as an integral part of the entire organization, and it is likely to conclude that this is a contract of service and not a contract for service, even though the level of control that you may have over that person is reduced. So the courts said in applying this test, it will consider the facts of each case and consider whether the worker was a vital part of the operation of the workplace. So I guess the logic behind this is if you are so integral to the way the work is done, how can you say that you are not employed under a contract of service? So you see, again, seems to be the court is not completely in favor of just using degree of control as the distinguishing feature. Yeah, and let me move on to the next slide where we bring in what I think is the current proposition in law, which is the mixed test. So the courts are taking various factors into account. If you look at the case of Ready Mixed Concrete and Minister for Pensions in 1968, this was a contract between a company and a lorry driver, and the contract very clearly states the lorry driver is self-employed. Now, in this case, the owner of the lorry was the lorry driver. He himself had to pay for insurance and he himself had to maintain the lorry. But the company here helped him to finance the purchase of the lorry. Additional facts here was he wore a uniform of the company. The lorry was painted with the company's colors. Now, he could delegate the driving, meaning to say, if the company says, I want you to drive from here to here, it doesn't mean that it was him who had to drive. He could delegate that driving to someone else. And he was paid based on distance. For every mile that he drives, he gets paid a certain amount. What did the court do here? The court said, I want to look at three conditions to determine whether this is a contract of service. Number one, there must be an obligation of the person to provide his own skill and work in return for the payment. So the court said, if you can delegate, you are starting to move away from employer-employee relationship. Very useful point. Number two, came back to degree of control. There must be sufficient degree of control. Nothing new, we know about that. Number three, an important point. The other provisions of the contract must not be inconsistent with it being a contract of service. Now, having taken all of this together, the court held that this was an independent contractor relationship and not an employer and employee situation. So the two most important aspects of this decision is the first one the court said is you must be using your own skill and your own time, your own effort. If you're doing that, I'm more inclined to say this is a contract of service. But if you can delegate this, I am less inclined to do so. Yeah. And then the court also looked at the contract. Does the contract have any clause which states this is indeed a contract of service? An earlier supra asked that question. What if I put that your salary shall be paid on this day? Now, if you have such a clause, again, it's indicative that this is more likely a contract of service. So you see that the control test is only one consideration. So now the courts are more inclined to use various considerations in making their determination. Move to the next slide, please. Again, on the mixed test, there's been further development on this area, which is why today most courts would approach the question of whether this is a contract of service or contract for service, in my opinion, using a mixed test. In the case of Kerwin and Dart Industries, now what happened here was again the tribunal used a mixed test and they set out various criteria before they decided whether this is a contract of or contract for. They did, and again I think one constant is the control test has become a subset of the mixed test. So it's not a standalone test, but it's not also wholly irrelevant. So the higher the degree of control, the more likely it is a contract of service. Whereas if you just looked at the control test, the higher the degree, it is a contract of service. Today, that's not the case. The higher the degree, the higher the chances it may be a contract of service. So that's one that the court looked at. The manner in which the work is carried out is something the court looked at. The means used to carry out the work. Where is the work being carried out? Whether the person was in business of his own account or whether he was an integral part of the business. So again, the integral or an organization test applies. And whether the person was required to provide personal service, another very important aspect. If you could delegate the job, likelihood that the court would say this is a contract for service, not a contract of service. And if I can move to the next slide, and I've got yet just one more case on this part. So if you look at Henry Denny and Sons against the Minister of Social Welfare. So this, you're talking about a shop demonstrator. You know, like when you go into a supermarket, you have someone who's demonstrating a product for that particular type of job. The contract clearly stated she's not an employee, and it also stated that she has to look after her own tax. So there's no deduction as a usual employment contract would provide. In that case, the court held that she was an employee and they used a combination of tests. One thing that the court did was they looked at degree of control. Again, it's a constant. The court looked at the terms of the contract of employment. Is there anything there which is inconsistent with it being an employment contract? The court looked at the level of integration of the individual and also whether the individual provides equipment, premises, or investment, and whether they employ other people. So this whole thing was taken into account. The court also looked at, is the person receiving holiday pay, sick pay, or is part of the pension scheme? And if you have these things, higher likelihood that the court would say this is a contract of service. If you move to the next slide, a lot of learning from this particular case. The court said that despite the fact that the contract stated that she was not an employee, the other terms of the contract, i.e. the requirement to be at work during those hours, requirement to wear uniform, requirement to carry out tasks in a particular way, all of this taken together led the court to conclude she was an employee. So when I step back and you look at all the tests that I've shared with you, we can conclude that the courts are now favoring the mixed test and they do not stick to any particular test. They will view each contract as a whole and they will examine each terms and compare them with the reality of the relationship before they make a decision. So it's not a simple distinction to make. And I move to the next slide, please. Next slide, please. Okay, sorry, the previous one, just the yes. What do you do with all of this? Don't worry about the law. Guys, the first thing you need to ask yourself is, what do you need? I want you to think about when you are buying a car, okay? What do you think about? You think about what are the purchase considerations that are relevant for you. Affordability, where are you going to use it? How many people are you going to carry? Right? So for example, if you're an estate manager in a plantation, you would need a four-wheel drive, all-wheel drive. If you're going to carry workers, you would need seven-seaters. So you have to approach this subject in that vein. Is a part-time contract something that is what you need for your operations? Is a fixed-term contract more appropriate, or is it a permanent employment that's more appropriate? Don't worry about the risks. What do you need? Choose the tool that helps you achieve your aspiration. Do not choose based on IR risk. In many cases, it may not be possible. When you choose on IR risk, you end up unchecked. They chose because they felt less risk. But what did the court say? They chucked it out. Okay. So I would like to conclude by saying that the needs of the business or the organization should be the driver on what, or rather on how best can you organize your company, and if that's the best way of doing it, what does this look like in terms of the relationships that I need, and not the other way around. Okay, that's all I have for all of you up to this point. Thank you very much. Over to you, Supra.
Thank you, Daman. That was very informative. Interesting enough, when you were discussing about, the difference between contract of service and contract for service, right? I think one case that is right now quite hot in the market is the Uber versus Mr. Farah and Mr. James, right, in the UK, where when they filed in, the industrial tribunal or the employment tribunal actually categorized them as an employee, right? And after two appeals, and I think right now it is at the Supreme Court, right, for them to make a decision. And today we are running this. The decision will be handed down tomorrow, actually, right?
Yeah.
Whether they will be treated as an employee or they will be treated as an independent contractor. Right? What's your view on that?
I tell you, I was really surprised by that decision, because I've got this thought process here. An Uber driver, can he have another job? An Uber driver, can he turn down the a particular drive, a ride? When you take all of that into question, and even an Uber driver, right? You see, I may be registered with Uber, but if I can't make it, I say, "Hey, Supra, yeah, I went and put myself up for this. This guy called me. I can't. Can you drive for me?" I can delegate that. So I'm really perplexed as to how the court came to the conclusion that it's a contract of service or an employer-employee, and which is why I think this has gone all the way to the highest court of the country in England. I'm really looking forward to tomorrow, but I am surprised that the Court of Appeal agreed that it was an employment contract.
Yeah. So tomorrow they will make a decision at the Supreme Court. So would you like to make a prediction based on your experience?
So with all this employer blood running in my veins, contractor, independent contractor is what I'm going to say.
But interestingly, in the US, in California, in the state of California, right? What happened was Uber, Lyft, Instacart, DoorDash, they basically pulled together the sum of about 205 million US, right? And put together and submitted and got a bill passed called Proposition 22, right? And the Uber drivers and all that are still treated as an independent contractor, right? But they will be allowed to form like a group, like a hybrid of a union, and they will be still entitled to healthcare subsidy, guaranteed minimum wage and all. But that was during Trump's time, lah, right? Because Trump used to be, very pro business, right? Now with who's the new president? I can't even remember.
Biden.
Biden. Okay, with Biden, and Biden is well known for being union friendly. So let's see whether he will overturn this Proposition 22. Okay, you have given a very good rundown on the difference between independent contractors and employees and the test, right? Just a few things I would like to clarify here, right? If would it make a difference, because you did mention that the definition of wages or salary could turn that whole contract around, right? If I say term it as a professional fee, right, for the services rendered and right, and I would indicate that you need to invoice me in order for me to make the payment and all that, would that strengthen the whole validity and validity of the contract for service?
It certainly would. Um, would that be on its own sufficient for the court to conclude this is a contract for service? I wouldn't say so. But would it strengthen? Definitely. Definitely. It's consistent with the intention of the parties for it to be independent contractor relationship.
Okay, in the contract for service, right, I'd like to see, right, would we are we supposed to still put clauses like non-compete, confidentiality, integrity, code of conduct, which normally applies to the employees, right? Intellectual property. So are we allowed to put clauses like that in that contract? Because you know what? They have got access to the company's information, right? They've got access to the company's employees, and in some cases, they might have access to the company's customers.
Sure. And I certainly think that the clauses you mentioned, except for the code of conduct, is separate. That's a bit more discipline related. But
Mhm.
confidentiality, IP, I think it equally applies to contractors as it would to employees. Like you say, you get a high level consultant where it's purely a principal contractor relationship, but you provide your full financial data, your full marketing plan, strategy. That's very, very valuable information. And I think it's only normal that you'd want to sign off on confidentiality and so on.
Thanks, Aman. Okay, right now, I think we are also overshooting on our time. So maybe I will address some key questions from the participants, right? We could address them. I think one question is the difference between a freelancer and a part-timer, and I think we technically would have covered that already. Or do you want to give a brief uh, answer to that?
Okay, so typically, if you, and this is more of the HR part of it, I would say that a part timer would have more rigid hours and fixed. But a freelancer, I think you have it's probably a lot more free and easy. There may not be a requirement for you to be attending a particular place. You could do it all at work. So I would say that that would be one big difference. But the main difference would be if you're a part-time employee, that is a contract of service, but a freelancer is a contract for service.
Okay, question two is, if an employee requests for a change from a full-time to part-time for a fixed term period, okay, due to personal reasons, how would you advise to handle that?
Okay, so long as the employee requests for this, you don't have an issue around consent. It's the employee himself or herself who's asking. I guess the company needs to agree to it. Is it possible for them to move the person to a fixed period of time? And if they're okay with that, it's a matter of having another contract to supersede the earlier contract and both parties signing off.
So it's mutually agreed, lah, right?
That's right. Yeah.
Okay, how this question? maximum number of times that I renew a fixed term contract?
Okay. So when someone asks me that question, alarm bells already, because you know why? The question seems to be, the approach is, how far can I push the boundary? Okay, now if you're going there and the industrial court is a court of equity and good conscience, it may just be the case one renewal might be one too many. So I wish I could tell you that a proper answer. My best suggestion would be, if you have a fixed term contract, have no renewals. You know, but obviously the more the renewals, the greater the danger. So now it's your risk appetite lah. You know, it's like some people gamble more than others. So if you want to gamble, you want to go to renewals and see what happens, I leave it to you. But best practice, fixed term should expire upon expiry.
I think the best advice would be to just follow Mr. Diamond's advice. Make sure that the job is permanent or the job is fixed term. Define that, and then decide whether you want to keep renewing or not. Right? Okay. On
Yeah.
part-time regulation, for those below 30% of work hours, right? Could I just consider them as freelance worker and put them under a contract for service?
Correct. Yeah. You know, it's by definition. It's by definition that because the definition is 30 to 70%. Now, whether the
Correct.
definition is really really rock solid, that's a different issue. But the law has stated that if it's less than 30%, it's casual. You see, so by
Mm.
definition, it falls in that category.
Okay, next question. Fixed term contract of staff. Okay, staff on a 1 to 2 years fixed term contract. Do we give them 2 months notice to the employees if they want to renew? As most of our positions in the company is on contract due to the current financial situation. So I think really the essence of the question here is, do the company give the employees the option to renew, or it actually the employer who gives the employee the option to renew, right?
Yes, correct. And in terms of notice, if you want to renew, there is no legal requirement. But obviously, if you don't provide any form of notice, the employee might be thinking that upon the expiry, I'm going to lose my job, and so they might be looking elsewhere. And if they secure another job, they may not be able to take an extension.
So the best practice would be to give that notice to indicate whether you're going to renew or you're not going to renew, right?
Correct. Yeah.
Thank you. Okay, I've got a few more. Okay, how do we handle variations in terms of employment contract? Okay, for example, currently the company is working on a 40 hours a week. Then the employer decides that we need to maximize our output, therefore we want to revise the work hours to 48 hours, still not infringing the Labor Act, right? What can the company do or what cannot the company do?
So general principles on variation would apply.
Mm.
Here, if you're increasing the hours of work, it would mean you'll have to get the consent of the employee. And typically, getting the consent of the employee would mean, what's in it for me, lah, the employee is going to say. So
Mm.
the variation would have to be obtained by way of some form of exchange, which is hopefully acceptable to the employee. So an increase in salary with a corresponding increase in hours, and that should be signed off. So you write down the terms saying these are the new hours and these are the new terms. But without consent, if you were to push this through, you're potentially in breach of the laws.
What happens if I can't get 100% of them to consent? Can I still proceed? Say I've got 80%.
Yeah. So you see, like in this case, I think one of the problems that I foresee is the reason why the person can't do the 8 hours. It may change from one employee to another. If it is the case that one employee, for whatever reasons, has got a strong case why they can't do it, then for you to impose it on them across the board, even though they said no, may be a bit of a challenge. It's different from salary reduction. salary reduction, basically, I'm not asking you to do more than hours. So I would say if you have a good majority, you should be able to push that through. But go back to the guys who said no and try to identify. Is it like, for example, if you want to ask somebody to come in and work on a Saturday, today we're 5 day week, but I want to go Saturday. But somebody says, I can't, because on Saturday I'm supposed to babysit or whatever. So in that situation, I think that's a valid explanation. You wouldn't want to push that through. But if the guy says, no, I don't want to, because, I just agreed on 40, why you want 48? That's not a valid explanation. You have a majority. I think you have a better chance of pushing that through.
Thanks, Raman. You have just changed from a lawyer to become a very good HR professional. Okay, there's two more questions, just two more. Okay, it's a new startup. We had issued employment contracts to all our employees and then realized that our contract was insufficiently drafted. It doesn't cover a lot of clauses like transfer, confidentiality, non-compete clause. So now that we want to update this, do we just issue a memo across the board, or do we redo a new contract to get the employees to sign again?
Okay. Transfer, I wouldn't be worried, because the law is clear that an employee can be transferred unless there is a clause in the contract which says you cannot be transferred. So even in the absence of a transfer clause, the law is ready to imply that. But for all the other clauses, confidentiality and so on, to me, they are not game-changing clauses. It's not like a extra hours of work, reduced salary, where the impact is immediate, financial, and so on. So if you have those kind of clauses that you want to introduce, I would suggest you come up with a policy, and that policy is it becomes a policy which is applicable to all employees rather than individual contracts to be signed.
Cool, thanks. Okay, what are your thoughts on company hiring someone for a 3 months fixed term and then later hires them permanently? I think this has got to do with something, some companies tend to, use this fixed term as a camouflage for the probationary period, right?
Yep.
Is there any potential danger to the organization for doing so?
No, I wouldn't say that. I will also tell you it's actually quite a clever way of doing it, because if you look at the Industrial Relations Act, you pointed out just now, rightly, Supra, there is provision which says for a probation of 12 months. So now I'm thinking, oh, lama, if I take this guy, put him on probation, and then if I let him go, I can kena 12 months. But what I heard from Daman, if the fixed term comes to an end, that's acceptable. Better that one, lah. I would say, that's nothing wrong with that. Nothing wrong with it. Because the whole issue of if the job is permanent and you're trying to disguise it, that only becomes relevant when you're renewing. But if you put someone on a fixed term for 3 months and the guy tak guna, buang. If the guy guna, you convert to permanent, no problem.
So you would advise for it, lah.
I mean, I wouldn't. You see, you've got to look at, some companies wouldn't do it because they have a probationary period. So the large guys, they want to play by their SOPs, their policies, so they wouldn't do it. But does it give you an advantage? I would say it does, because that 12-month probation maximum doesn't apply for someone who's on a fixed term which expires and the person is terminated. So there is an IR advantage that you could gain from that method.
But I think the big question will be whether the employee would want to join you for the 3 months period, lah.
You're right. That's the practical, yeah. And then when you say, but listen, after 3 months, if you're good, I will keep you. The guy may say, then you bagi probation lah. And then you are into that discussion lah.
Okay, I think we have addressed most of it and we are really running late. So, I think we'll wrap up here. Thank you so much, Daman, for taking the time to be with us, and sharing your knowledge and information and experience. It's been quite amazing and interesting. And, and I believe a lot of the participants would have also learned quite a bit in really thoroughly understanding the difference between the contracts and how do you actually use the contracts, for the business, to run your company, and not to try to mess around with the contract and abuse it, which might bite you back later. Right. So
Most
thank you so
welcome.
much, Daman, and thank you all for joining us today. And I believe that's all the time we have for you today. And I will see you again next month for the Art and Science series. Thanks. Ciao. Ciao.